my name's Caitlin Zaro. I'm an attorney at Whiteford, Taylor and Preston. And this is the MSBA Real Estate Sections Lunch Discussion Group. This is our April meeting. And of course, our April meeting is always our case law update. And so Mr. Ed Levin and Mr. Paul Levin are here today to provide a summary of the notable cases that have occurred here in Maryland over the last year. There are additional materials in addition to the PowerPoint. So the materials provide a longer summary of all the cases that are notable. And the PowerPoint will provide a summary of the most notables. So please look out for that. They'll be linked in the chat as well as uploaded to the section page. So plenty of availability for you to access those materials. This is the second to last meeting of our year. So this is the April meeting. Our May meeting is moved. It is not the second Tuesday, but rather Tuesday the 24th. Tuesday the 24th. Mr. O'Connell will be doing the update from the Maryland legislative session. So that'll be our last presentation of our term. So I believe that's it as far as updates. Welcome everyone, and I'll turn it over to you, Mr. Levin.
Caitlin, thank you very much. I'm Ed Levin. I'm a member at Gordon Feinblatt. Presenting with me today is Paul Levin, who's a partner at Venable LLP. We're going to be talking about Maryland cases for the, I guess, fiscal year from April 1, 2021 until last week, March 31. So this is a continuation in the series of case law updates that we've presented for the last several years. These cases are what are of interest to us, and we have summarized in the paper that should be attached to your materials, or you should be getting an email about them. There are about 40 cases that we've written up at some length. And then today in a presentation, Paul and I will be talking about 24 cases that we think are particularly interesting. Anyway, they're interesting to us. If they're interesting to you, that'll be great. We will be taking questions as you'd like. I assume we have a chat possibility, and if we have questions that come in during the presentation, we'll take them as they come in so that we can answer the questions about particular cases near those cases. And if you'd like to ask questions at the end, we'll take questions at the end. As in the past, we've divided our cases by court of appeals, Court of Special Appeals, both the reported and then unreported cases, Fourth Circuit case, District Court of Maryland cases, Federal District Court cases. And then as an extra bonus, as it were, we'll be talking about some cases that are in our list because of COVID together as at the end of our presentation. First, our Court of Appeals cases. And the first case is called Angel Enterprises against Calvert County. In this case, we had a situation where somebody wanted to build a house in Talbot County. Sounds like a nice idea, and the person got a building permit to build the house. That also sounds like a good idea. But what wasn't such a good idea was that there was no permit issued to build the driveway to Route 33. But that did not stop the owner developer who thought he wanted to go to Route 33. So he went ahead and he knocked down some trees and he built a path to Route 33, a driveway to Route 33. The Talbot County Chief Code Compliance Officer didn't like that and started imposing violations. civil violations added up to $713,400. It's an awful lot for a driveway. Well, there were appeals to the administrative side of things and then into the courts, into the Court of Special Appeals. Remember, this was the Court of Appeals case. The Court of Appeals took cert, thought about the case, and then sent the case back to the parties to ask them to brief whether Talbot County Board of Appeals had subject matter jurisdiction to impose the assessments. The answer came back no from the Court of Appeals. That in charter counties, there was no subject matter jurisdiction, no ability of the board to impose these penalties. The charter counties in Maryland are the 11 counties as follows: Anne Arundel, Baltimore, Cecil, Dorchester, Frederick, Hartford, Howard, Montgomery, Prince George's, Talbot, and Wycomico. That's way the majority of people in this state. And the decision surprised a lot of people that charter counties boards don't have the authority to impose civil fines, that the district court, state district court has the jurisdiction to start at that level and then work your way up. It's possible that there could be two appeals now when situations occur like this. One to the local Board of Appeals on the substance of the violation, and a second concurrent appeal to the courts on the amount of the civil fine. We shall see. The next case, Hector against Bank of New York Mellon, excuse me, is a lead poisoning case. And this is a case that we talked about previously because it went through the Court of Special Appeals. Bank of New York Mellon foreclosed. People were living in a property in Baltimore City, which obviously had lead paint. The overlap between the bank as foreclosing party and purchaser at the foreclosure sale and the residence was extremely thin. And the court relied on the fact that there was the right under the deed of trust. Somebody thought that he or she did a good job drafting because it gave the mortgagee the right to possession. That great benefit to the mortgagee may have come back to hurt the mortgagee. And of course, what really hurts the mortgagee is the Baltimore City Housing Code, where it defines owner very, very broadly. And the Court of Appeals in this case held that there was liability, even though there wasn't any fault, any action as such. It's just that under the statute or ordinance rule, there was a statute that protects a class and included the plaintiff in a violation of the statute, i.e. ownership of property containing lead paint. That produced a nexus that was strong enough, obviously under the facts, to make Bank of New York Mellon liable. The case will be remanded for further consideration. But I wanted to point out a case that's noted at the bottom. It's not, I don't have a separate slide for this in our materials, but it is written up in our paper. It's case number 28 in the paper called Kelly against CFN Receivables, unreported case in the Court of Special Appeals. This is how far these cases reach. The facts of Kelly, I copied from the Court of Special Appeals decision. Usually we summarize the facts, but there are a lot of people who would think I was making it up, I think, if I paraphrase. So I use the exact language. The plaintiff lived in the subject property from 1997 to 2001. That's a long time ago. She was an infant at the time and turned 18, became of majority age recently, and then she filed a lawsuit 18 years after the lender in this situation had any involvement with the property. The plaintiff's family had been evicted from the property but stayed there. And the court said there's lead paint liability. So be very, very careful. Paul, do you know anything about Melanie Drive?
I do. Thank you. Thanks, Ed. Thanks again to everybody for joining us today. This case, the RDC Melanie Drive v. Eppert case, is a case about interpretation of a declaration. So RDC in this case is the owner of the Links Golf Course in St. Michael's, and they wanted to expand their property to include a driving range. And they purchased lot 6 of a neighboring residential community. The other neighbors in this community, called Swan Point, opposed that plan. They didn't want the driving range in their neighborhood. And they pointed to the declaration, which limits the uses to general residential uses and not commercial uses. However, the declaration was pretty general and it did not expressly prohibit commercial uses or a driving range use. RDC applied to the local jurisdiction for a variance to alter lot lines, and that variance was granted. The permit board didn't agree with the residents that the terms of the declaration prevented the use. After that, the neighbors amended the declaration to specifically prohibit use as a golf course. The neighbors then sued for a declaratory judgment that RDC's proposed use was in violation of the declaration. The Court of Appeals here found in favor of the neighbors and prevented the use as the driving range. The court read the initial declaration broadly to protect the residential uses, based on the unambiguous intention of the declaration, using a reasonableness standard and not a strict construction standard. The court also found the amendment was proper because it merely implemented the initial declaration terms and was not prohibited as it would have been if it had imposed new restrictions on a minority of owners. So as a result, the court stuck with a broad reading of the declaration to preserve the general intent and prevented the driving range here. Our next case is the Velicki case. So this is about the requirement of a landlord to hold a license in order to evict a tenant. So the owner of the Velicki building, the owner of the Copycat building in Baltimore City leased units to tenants, and when those tenants didn't pay, they served an eviction notice. The landlord then moved to evict under the real property article. The tenants, however, claimed that the landlord was not entitled to the eviction remedy because the landlord was unlicensed and therefore did not meet Baltimore City requirements. A divided Court of Appeals, however, found in favor of the landlord here. The court found that ruling otherwise would prevent the landlord from having a statutory remedy, which was unreasonable. The court made a distinction here between the requirement for having a license in order to lease property and having a license in order to have a remedy against the tenant who had not paid. There is legislation pending on this issue at the Maryland General Assembly that would require a landlord to show they were in compliance before moving to evict a tenant, both with licensing laws, but also with lead paint requirements. So that also could go back to the Hector lead paint issue that we discussed earlier. And that's House Bill 174. So we'll see how that tracks.
$174 was not finished a day and a half ago. Last night, everything finished. The General Assembly finished its session, and 174 was probably passed yesterday, but Bill O'Connell will tell us more about that next month. Wheeling against Celine. we had a case several years ago called Nichols against Mount Vernon, something or other, where the Court of Appeals held that you can use self-help if you don't violate the peace to evict a tenant, residential or commercial. That if, in the Nichols case, the landlord went into the premises when the tenant wasn't there and you evicted the tenant, changed the locks, moved things out, and so on. That produced a firestorm in Annapolis and produced Real Property Article 7.113 that prohibits self-help in evicting residents. Wheeling involves a situation where there was no eviction, and yet there was liability. And that was because the servicer sent letters to the people. One was an owner, one was a tenant, and said, you got to get out. And the people were emotionally distressed at that notice, even though the servicer, landlord, owner, nobody moved further than that. And this case at the Court of Appeals level, again, reverses the Court of Special Appeals and holds that this threat was enough to trigger statutory liability. Emotional distress usually requires, to be able to get damages for emotional distress, usually requires some sort of physical manifestation. The court looked hard and said, well, maybe there's something there. So this was a 5-2 decision. Judge Getty at the time, now Chief Judge Getty, wrote a very strong dissent, and he was joined by Judge Booth, but he only had one other person on it, so it is a minority opinion, a dissenting opinion. Both the majority and the dissenting opinion say they're relying strictly, or heavily, I should say, on the plain language of the statute. Now, what does that tell you? If two smart judges can say they're reading the plain language of the statute and come out with diametrically different answers, that tells you something. Chief Judge Getty said, in addition to reading the plain language, I'm looking at the legislative history, and this kind of situation should not have produced liability. But again, dissenting opinion does not carry the day. Okay, we're going to move to Court of Special Appeals reported cases. And the first is called Jones against Ward. This was handed down just in February.
So this is a case about whether you need to have the original of a promissory note in order to enforce a loan. As we know, frequently happens that lenders lose notes and they sign a lost note affidavit and they declare that they are the holder of the loan, and then they move forward to enforce their rights, and it's usually not an issue. But here we had the same issue that came up, but the lender that lost the loan, that lost the note, was no longer the holder of the loan, which caused the issue here. So Phyllis Jones defaulted on a loan originally made by World Savings Bank in 2014. World Savings Bank lost the note and executed a lost note affidavit before transferring the note and the loan to Wells Fargo. Wells Fargo later signed other lost note affidavits and then transferred the loan to Truman Title Trust LLC, who became the owner. Jones claimed that Truman Trust, the then holder of the loan in this case, did not have standing to prosecute the foreclosure because it did not hold the original note and was not entitled to sign the lost note affidavit and enforce that claim under the Maryland law. Jones also alleged other defects based on the long chain of transfer of the lender's interest in the loan. Now, the express language of section 3301 of the commercial law article only provides that the party who lost the note can enforce it. In this case, that would specifically be World Savings Bank, who hasn't had an interest in this loan since 2014. The UCC overall was updated in 1997 to allow the current holder of the loan to enforce, even if they were not the party that lost the note. However, Maryland has not enacted this change to the UCC. Regardless, the court here allowed the lender to enforce the note in the foreclosure proceeding. They found that Maryland law allowed other protections to the borrower that would prevent multiple parties from enforcing or attempting to enforce that same note. And the court was satisfied that the trustee who filed the claim was the proper holder. Finally, the court determined that finding against the lender would give the borrower a windfall by allowing her to avoid foreclosure. So here the court did not stick to the letter of the law as it is, but essentially read in this new ability of a lender who did not originally lose the note to still enforce. So it does sound like we might need an update to the Maryland UCC on this point in the same way that it has been effective overall under the UCC.
Sounds like we don't need the update to the UCC because the courts have done it on their own.
So this is the MCBbury development case, and it's a SLAP suit, anti-SLAP suit case. So here, the developer was seeking to amend the Woodbury planned unit development in order to build more townhomes and remove parking spaces on a then vacant lot. The neighbors, however, opposed the developer's request. The developer had filed to have a minor amendment to the PUD in order to allow the development. The developer filed a lawsuit against the neighbors, claiming economic interference and delay damages for $25 million, essentially for trying to get in the way of the new development. The developer also claimed that the declaration covering the property prevented the neighbors from opposing the developer, and that any action required the developer's consent because the developer controlled the body under the declaration. The neighbors, in turn, claimed this was a strategic lawsuit against public participation, a SLAP suit, and that they had a right to comment on the developer's plans. This was a case of first impression in Maryland, and the court agreed with the neighbors, finding the developer's claim was an unpermitted SLAP suit. The claim, the court said, was intended to inhibit the exercise of the rights of the neighbors, and that the developer acted in bad faith by bringing this claim. The court also found it was a matter of public concern, and it was proper for the public to comment on it, and that the individuals had not waived their rights to bring this claim, even though they were parties to the declaration. In all, the court enforced the anti-SLAP legislation and protected the speech on First Amendment grounds. Now, right after this, there was a case about the underlying approval of the amendment to the PUD, which was approved as a minor amendment, even though this SLAP suit was thrown out. Essentially, the court in that case, which I think we have in our paper, but it's not on this slide, the court generally found that the approval was proper as a minor amendment because the PUD gave sufficient flexibility to move uses between properties within the PUD. However, on one point, the court found that the amendment needed to be done as a major amendment because the developer was attempting to add property to the PUD, and that was outside the bounds of a minor amendment alone.
So for those of you interested in following up on Paul's last comment, it's case number 19 called Millrace Condominium. So last session of our group meeting, we spent the entire time talking about the shelter senior living case. I just want to say today, one or two points. First of all, the holding is that recordation and transfer tax are based on the value or consideration for the real property, not personal property, not intangible personal property, not goodwill. In this case, as it worked its way through the tax court and the circuit court, the tax court had said that I'm going to bifurcate the case. First, we'll decide whether the whole bundle of sticks, the whole purchase price for the senior living facilities, which includes all in real property, tangible personal property, intangible personal property, is all subject to tax. If I decide that it is not, by the tax court, then we'll try to figure out how much of the consideration was really for the real property. As I indicate on the slide, the purchase price was $93 million for 3 senior living facilities. $40 million was the amount that the taxpayers claimed was the value of the real property. Well, based on the ruling of the tax court never broke down the valuation of the real versus personal property, but based on the decision of the Court of Special Appeals, that's exactly what the tax court has in front of it right now. And we shall see ultimately what the tax court decides on that. The next case, Simmons against Maryland Management, is a scary case for us because we're lawyers and we're used to cases where other people get sued. In this case, the lawyers got sued also. And the reason that the litigation existed in the first place was because somebody or people, or the defendants, I should possibly say in this situation, brought an action against the individual plaintiffs for past due rent that was more than 3 years old. This has been an issue that's been kicking around in Maryland for a long time, and certainly for the last 20 years. There were cases called Tipton and Smith against Wakefield to try to determine whether you could move the 3-year statute of limitations. And if you read the Tipton case from 2001, you saw that the Court of Appeals laid out a plan as to how to extend the statute of limitations. You say you were going to do it. The word seal itself wasn't sufficient to make it a specialty, but that case made it to a lot of people, not to everybody, but to a lot of people, that there was an obvious way and a prescribed way of how to extend the statute of limitations. Well, Tipton was followed by Smith against Wakefield, which we talked about 3 years ago, where the Court of Appeal said, no. Those statements that we made, they really didn't count. They were footnotes. Yeah, they were in the text too, but that wasn't necessary for the opinion, so we'll call it dicta, and you can't extend the statute of limitations beyond 3 years. Well, somebody wasn't paying attention, and these plaintiffs got sued for debts that were more than 3 years old. And there's liability here, ultimately, that includes the debt collectors and the lawyers. That's why I say this is a scary case for us. Okay. We're going to switch our focus to unreported cases of the Court of Special Appeals. Some of these cases are every bit as interesting as the reported cases, but you can make that decision for yourself. The first one is called Arundel County against PPE Casino Resorts. This is the Maryland Live Casino in Arundel Mills, the county assessor assessed the property and did it on the basis of the income from the property. The taxpayer said that's not the way to do it. They looked at the numbers. The difference in the valuations between the taxpayer's number and the tax assessor's number was $55 million. That's a lot of casino chips. And that's exactly why, because the income from the property was based in part on the casino earnings. So the taxpayer said, wait a minute, that's the business side of things. And if it moved, the case is about what the real property is worth. Excuse me. If the casino moved, the real property would not be worth the amount that you're saying it's worth. And it should be based, the assessment for real property tax purposes should be based on the cost of the land, or more appropriately on the sales approach. How much would it sell for? How much would this land sell for? This was the winning argument, and it saved the taxpayer an awful lot of money. To follow up on the case, something that wasn't directly addressed there is, what if you have a situation where you've got a tenant that's paying percentage rent and does really well and pays you a lot of percentage rent? Is it appropriate for the tax assessor to take the income you're getting, capitalize that, and roll it into the amount that the property is taxed? That has not been decided yet, and we'll see how that comes down if and when it does.
All right, this is the Carrington condo case. So this is a case about the power of a condo association to levy dues, particularly when there are multiple classes of owners. This association particularly governed a property in Montgomery County that included both townhomes and garden units. However, 100% of the members of the board own townhomes. So we can see there's a problem brewing here, and it came to a head when the board voted to require that all residents pay maintenance fees for outdoor space that was located only around the townhomes. So it doesn't sound like much, but this raised the assessment of the garden owners by over 45% of their prior assessments. One of the owners of the garden units objected, claiming that this was in violation of the declaration and the bylaws. They filed a claim with the Commission on Common Ownership Communities for Montgomery County, which ruled against the owner, and she appealed to the circuit court. The board, in response, argued that it was entitled to the benefits of the business judgment rule, basically that it should get deference on this type of decision. However, the circuit court held that the board was subject to the disinterested directors rule, and the Court of Special Appeals agreed. The holding here is that the business judgment rule does not apply if there is fraud or bad faith, or if there is a showing of a conflict of interest. In this case, the court remanded for further consideration, but it certainly looks like there was some sort of conflict here that'll be taken up by the next court. So the Falls Road Community Association v. Becker case, and this is about whether an issue, collateral estoppel issue, already determined in an initial rejection of an approval, prevented the developer from seeking approval of an amended development plan. So this case for a proposed development in Baltimore County on Falls Road goes back to 2004, where the original plan for the community had 10 houses that would be constructed. And after rejection, the number of houses was later reduced to 8 and then to 5. Now, the key issue here was whether the initial denial of the approvals in 2004 by an administrative law judge prevented the developer from raising the same issue. Here, safety of cars turning onto Falls Road. Now, the number of homes in the development did not resolve the safety issue. Cars are still pulling on and off of Falls Road in an area that had 8 on and off entrance ramps to Falls Road, a pretty busy corridor. Here, the court found the collateral estoppel did apply, and the developer was prevented from seeking permits for the same program because the same issue had been decided on the merits. It was a final determination. The same parties were involved, and the claimant here had the opportunity to be heard. So really an application of the collateral estoppel principles, and really needing to be careful here in reapplying for permits, that there's really a different issue, or the issue involved is really addressed directly.
Please note that cert was granted on this case. We'll see what the Court of Appeals does.
All right, so the next case, Gestamp Wind v. Alliance Coal, is about light and air easements, or not the right to light and air easements. So the facts in this case had the Matiki Company operating a coal spoilage pile in Oakville, Maryland, that rose to be over 3,200 feet high. That pile was permitted by the Maryland Department of the Environment. Gestamp, the neighbor, operated a wind farm and claimed that the pile blocked access to wind that it used to generate energy. Economic harm. Gestamp filed a nuisance claim against Matiki on the basis of this claim. The court, however, found that property owners in Maryland have no right to wind or air access. Maryland had rejected the ancient lights doctrine of English law as far back as 1857 and found that it would be contrary to development progress in Maryland. The court also cited precedent where one neighbor was allowed to build a shed on its property that blocked light and air to its neighbor, as long as they obtained permits for the construction and complied with zoning laws. The court also affirmed that without a contract between Gestamp and Matiki, Matiki had no duty to allow free wind access.
This case has received some national attention. Our next case is about Glenelg Country School. This is not a picture of Glenelg Country School. It is a school, and it's a gorgeous tree, and that's why I put the slide in, just because I thought you'd like to see it at this point. What this slide has in common with Glenelg Country School is Glenelg Country School has a lot of grass around it. It's in a beautiful setting. It's got beautiful homes around it. It's not like a city school in the middle of a block. And Glenelg Country School had easements from its neighbors who had apparently pipe stem or flagpole lots. And ultimately, Glenelg Country School got exclusive right to use the easements, which I don't understand unless the people who had the fee ownership also had access to another road. So possibly that was the case. Glenelg Country School went to Howard County and wanted a special law enacted for its benefit. And we asked the question, what could be wrong with an amendment to the Howard County zoning regulations for conditional use? It applies only to private academic schools with an adjacent exclusive use easement. And then there are more details in the second bullet point. But the point of the case was that there was only one candidate that qualified for these purposes under these rules. And that was this particular school. The Court of Special Appeals said, no, 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 no. The Maryland Constitution, Article 3, Section 33, has a rule against special purpose legislation. This is special purpose legislation. And how do we know? There are 6 steps to decide what is special purpose legislation. You meet 5 out of 6. The 6th step is the inclusion of the name of the particular party who is benefited. Although that was not included, the legislation doesn't say Glenwood Country School in itself. Court of Special Appeals said that's not important. This violates the Maryland Constitution, and it's a no-go. Paul, I thought this was a little surprising that it's not unusual, certainly in the country, to have special purpose legislation.
Yeah, we've certainly seen it in other jurisdictions, even with that general a description that could only apply to one entity. But here it looks like a pretty specific application of the unconstitutionality. So there you go.
Now you can go, Intermore.
So this is the Intermore case. So Intermore v. U.S. Wind is really a case about lien rights, and here in particular, lien rights on the Outer Continental Shelf, outside of the bounds of the state of Maryland, importantly for this case. So Intermore was the contractor installing a weather tower 10 miles off the coast of Ocean City. The purpose of the tower was to collect wind data and to figure out if it was a good place to put a wind farm. When Intermore wasn't paid, they brought a claim of lien under the real property article in circuit court. Now Intermore cited the Outer Continental Shelf Act, which generally applies the law of the closest state in a number of circumstances. However, the Court of Special Appeals here rejected Intermore's claim. And they said this was not a choice of law question, but instead, Maryland did not have the authority to enforce a lien on property outside the boundaries of Maryland. The court determined after looking at the Maryland Constitution and related law. So no authority to enforce a lien, so no right for lien recovery to Intermore. So there's a takeaway here for similar projects, really needing to rely on contract rights or other remedies in order for contractors to get paid in these cases, and could really be an issue in other states as well, depending on the state law and state constitution of other states.
Most of the cases that we talk about are of interest to us, wonky real estate lawyers. This is a case that was of interest to the people who read the general newspapers to keep track of the goings on in the discussion about where the MIA, the Maryland Insurance Administration, is going to be, because it occupied such a big hunk of downtown Baltimore office space and may have implications for other spaces. MIA wanted to move from downtown probably to get free parking, or primarily to get free parking was the word on the street. It changed its mind and canceled the RFP. Now, I'm going to, first of all, give you a spoiler alert. The MIA is still a tenant at 200 St. Paul Place, St. Paul Plaza, downtown Baltimore. And then I'm going to tell you 3 fun facts. Number 1, the insurance companies that are regulated by the MIA pay the expenses of the MIA. Number 2, after a bid for certain state contracts, including the lease for real property, a procurement officer may cancel a request for proposal, the RFP, before the award if the procurement officer determines that the cancellation is fiscally advantageous, otherwise in the best interest of the state. And the last point is that a procurement officer who determines that renewal of an existing lease is in the best interest of the state may negotiate the renewal without soliciting other offers. That's the little blurb on Maryland procurement law. So again, the MIA wanted to move, asked for an RFP. An RFP went out. Montgomery Park won the award. 20 candidates applied or something like that. MIA and Montgomery Park negotiated for 11 months on a lease. A couple days before the issue was going to go to the Board of Public Works for the state, the insurance commissioner told the procurement officer that the insurance commissioner did not want the move to go ahead, that the issue about free parking wasn't so important after all, that the insurance companies, which would have picked up the moving costs apparently, weren't keen on having a second move within 10 years. And there were some other points that made the insurance commissioner not want to go ahead. The amount of rent savings, by the way, supposedly net of moving expenses, whatever that means, was over $300,000 a year on a 10-year lease. That's $3 million that the state would have saved. Well, Montgomery Park appealed, protested is the word, on two levels. One was that it should not have had its RFP canceled, and the second was that the lease should not have been renewed without giving it a chance to fight that battle. A lot of the discussion on the various levels up to and including the Court of Special Appeals was the basis that the procurement officer was supposed to act, the guidelines, and it was ultimately decided that the rules were arbitrary, capricious, and unreasonable. Those were the key words. And if the procurement officer was not arbitrary, capricious, and unreasonable, then the decision would be affirmed. The procurement officer, as it turned out, didn't do anything independently. The insurance commissioner sent a note on the same day. The insurance commissioner listed 3 or 4 reasons. On the same day, the procurement officer canceled the RFP just 3 or 4 days before it was supposed to go to Board of Public Works, but not independently evaluate those points that the insurance commissioner made or find any new ones. Didn't do anything. Court of Special Appeals said, well, it's up to the protester, the challenger, to prove to the contrary. The procurement officer doesn't have to prove anything unless it was arbitrary, capricious, and unreasonable. And that was found not to be the case. That was on the challenge to the move. Then how about the challenge, the protest to the lease renewal? Montgomery Park lost that too because it did not have standing. Once the RFP was lost, it was like everybody else in the world. It could look at the lease, it could look at the lease renewal, but it was not, quote, next in line for the award, so it did not have standing.
All right, this is the Peterbilt case. This is about the requirements to exercise a purchase option in a lease, with the court finding that in order to exercise, Peterbilt in this case, the exercising tenant, had to be specific and hit all of the requirements for exercise or otherwise failed to satisfy a condition of that right. And so here, Peterbilt leased property from Capital Gateway in Landover. The lease included a 7-step option process in order to exercise. And Peterbilt got most of the way through, but failed on the 6th step, which was actually just a requirement that appraisers, as selected by either party, had to meet and confer on the value of the property within 30 days. Apparently, the property included a significant parcel that was undeveloped, so there was a variation in appraised value. The appraisers didn't meet within the 30-day period. Peterbilt requested an extension, but Capital Gateway refused to give it. The court here found that Capital Gateway was not required to sell the property, as I said, because Peterbilt had not satisfied all the required steps for the option. And the Capital Gateway was not required to give more time, really sticking to the express language of the contract and not needing to include any other terms. Now, interestingly here, Capital Gateway in response had asked for reimbursement of its attorney's fees based on the terms of the lease, basically that Peterbilt had brought them into this claim and lost, and that Peterbilt should cover Capital Gateway's fees. However, the terms of the lease only allowed for recovery of attorney's fees related to a default under the lease. Here, there was no default, just Peterbilt's failure to satisfy a condition that would have allowed it to exercise the option. So there was no recovery of attorney's fees. There could have been recovery of attorney's fees under an indemnity provision of the lease, but Capital Gateway didn't bring that issue up until the appeal, so they lost that right. But overall, really two specific findings for this case, and really quite important. One is about following the express procedure in a lease or in any document in order to exercise a right, particularly when the counterparty does not want you to exercise that right. And the second was about careful drafting of attorney's fees provisions, so that if intended, they would apply in a case like this, where one party brought claim against another, even if there was no default.
Okay. We have finished discussion, except for the COVID cases, of state court cases, and we'll turn to the Fourth Circuit Court of Appeals. This case, Alexander against Carrington, is a case that affects lenders and bankers and mortgage servicers and mortgage lenders more than straight up real estate. But it is important. It was the subject of Senate Bill 217, which was passed in the House, passed in the Senate, and died. And the reason was because the same versions weren't passed in both houses, and two houses did not get together. So the bill that would have changed the applicable law will not be effective this year. This case involved two or more borrowers from a mortgage servicer, mortgage lender, and a mortgage servicer, and they said, we'd like to pay online, we'd like to pay, and found out immediately that our accounts have been credited. We'd like to have this right to do that. And the servicer said, well, we'll do that for you if you give us $5 each time you do it. And they said, fine. And they paid the $5, and then they turned around and they sued the lender because they said, if you look at a note, the promissory note says, I promise to pay $100 a month. If I'm late, I'll pay more. If I'm late, I may pay more interest. But I'm not late, and you charge me $5, and you can't do that. And the district court threw the case out very quickly, but the Fourth Circuit said no. The statute is written in a way that does not authorize this. And the argument in the case was what the difference between not prohibited and permitted by law. And the difference in those two terms made all the difference in the decision, because there was no specific permission by law that said you can charge $5 more if you have the borrower requested or something like that. So that was not permitted by law. It wasn't prohibited because there wasn't a prohibition of having an agreement between the parties to make the extra payment. The statute would have Senate Bill, the bill was not a statute, Senate Bill 217 would have changed this, but it died last night. In the District Court of Maryland, we find our friends, literally the friends of Lubavitch against Baltimore County back. We had studied this case, talked about it a few times when it worked its way up in the Baltimore County Circuit Court and then in the Court of Special Appeals, where there was a desire to improve, to enlarge a house in Towson to be used for religious purposes and college students to study and to have holiday meals there. But there was a little problem of a setback that was in the way. The owner of the property disregarded the setback requirement and built an enormously enlarged facility, and the county courts and the circuit court, Court of Special Appeals rather, held no, you have to pay attention to the restriction and knock the improvement down. The owner of the Lubavitch friends of Lubavitch sued in District Court of Maryland, federal court, under a host of reasons, the First Amendment, the 14th Amendment, defamation, and lost on all counts. The would not surprise me if this case is appealed. This is the second ugliest picture in the world now. It's tied with everything that has the word Ukraine in it, unfortunately. But we have a few cases that we want to touch on briefly that affect COVID and COVID affects them. The first is an insurance policy. This is the Cordish Company against affiliated FM insurance, and Cordish paid $2 million for business interruption insurance. And then there was business interruption because of the fact that COVID stopped the operation of the facilities, but the court denied coverage because there was no physical harm to the property. There was a contamination exclusion that prohibited coverage, and it didn't matter that locations were closed. This is a case that has been played out in courts around the country and with pretty much the same result. On a personal note, I would say that if I were the judge and somebody walked in with a business interruption insurance policy that had the word all risk on it or comprehensive, which these policies did, I would say all risk means all risk, and that's somebody's risk, and therefore the insurance company should pay. And I would say comprehensive means it includes everything. And if you're going to put comprehensive on the cover sheet of an insurance jacket, then you should pay for all risk. But I'm not the judge. Back to your old friend Jones against Ward, Paul.
So this is the same parties from the lost note case that I discussed earlier. So from that case, the foreclosure proceeding moved forward. The home, Mrs. Jones' home, was sold, but she requested in this case that the sale be vacated, claiming that she was entitled to forbearance under Governor Hogan's executive order from October of 2020. However, the court found that she had already been served with notice of intent prior to the date that that executive order would trigger. And as a result, she didn't have any rights to benefit from that executive order. It was prospective only. Mrs. Jones also claimed that the foreclosure should be vacated because the purchase price was suppressed. The sale was held during that early period of COVID, and she claimed that there weren't sufficient buyers to make sure that there was a reasonable price obtained for the house at the foreclosure sale. The court, however, found there was no specific basis for that claim, and the mere fact that the sale was held during the time that COVID was causing issues in the area did not make the foreclosure sale improper. And in fact, they found that the price was not low enough to shock the conscience of the court. Here they said it was 83% of the Zillow value. But the court cited cases in Maryland where Maryland courts had ratified sales for as low as 35% of some determination of the fair market value in this case of that property. So the long and short of it was there was no recovery here. Foreclosures could move forward in Maryland if notices had been filed before the effective date of Governor Hogan's executive order.
Another foreclosure COVID case. This one just says that when you have a foreclosure sale advertisement, it typically says that interest on the unpaid purchase price, if the purchase price is $1 million and the down payment is $100,000, is a $900,000 amount of unpaid purchase price. And the ads usually say that interest runs at some rate, let's say 5%, just to pick a number, on the unpaid purchase price. Well, there's an exception to that. It runs until settlement. So there's an exception to that if some extenuating circumstances will stop the interest from running. In this case, the issue came up not only interest, but real property taxes. There was an extended period of time because of the COVID restrictions. And in this case, the Court of Special Appeals held no, interest is not stopped. The person who has the, who gets in the way, who causes the stoppage that stops the interest is not the circuit court, it's not the chief judge of the Court of Appeals. So interest has to run. And the last case we're going to show a slide about is called Willowbrook Apartments, which was from District Court for the District of Maryland, Federal District Court, Baltimore City, Howard County, and the city of Salisbury enacted legislation that restrict rent increases on renewals or charging late fees during COVID. And the landlords, a large group of landlords, said this violated and impaired their vested real property rights. The Federal District Court said that the Maryland law was a little broader than the federal law, and there had actually been a violation of a vested right insofar as these laws would have stopped the following situation. A tenant could have been told on day one, there will be a rent increase next month of $20 a month. And then the COVID mandate came in between that notice and the date that the rent increase would be effective. That, the court held, would have been a violation or was a violation of the vested property rights of the landlord. All of the other aspects of the law were endorsed, and that's the one note that changed. We have, if we're very fast, a few minutes. I think Angela has been nice to say we could run over, which we've already done, but I see a number of questions in the chat. I'm wondering if we can figure out whether there are cases in here other than how people can hear.
I don't see any substantive questions just yet, Ed.
Oh, okay, good. Well, that tells us that Paul and I were very thorough and complete and included all the information that you need, but we do have probably literally 2 minutes to take any substantive questions that you may now have about any of the cases that we addressed. Terrific. I see that our paper was put on the chat, and I'm not a very technically savvy person, but I guess that means you can get it off of the chat and have a copy of the paper that we wrote that has the cases that we discussed, plus more cases. One thing that I did not say was that the cases in the paper are linked, that if you click on the cases in the right way, you can go to the name of the case, you can go to the case itself if you want to read more deeply and see what the court actually said. So that being the case, thank you very much. I appreciate your staying with us for the extra few minutes. I'm sure many of you will be back to hear about our legislative session that Bill O'Connell will present next month on the 24th of the month. We'll get notices about that.
Thanks to everybody for joining today.
Thank you, Ed. Thank you, Paul, for a wonderful presentation. We really appreciate it.